Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law. And today I want to talk to you about a question that comes up from time to time. And it's, will my revocable living trust avoid probate? And the answer is, it depends. Now, if you've established a revocable living trust, which I'm just going to call a trust, well, congratulations to you. You're definitely on the right track in creating a comprehensive estate plan. However, you're only halfway there. Many people believe that because they took the time to create a trust, that their estate will automatically avoid probate and they will not have to take any additional steps. Well, unfortunately, this assumption creates a false sense of security. The key to probate avoidance is ensuring that when you pass away, there are no accounts or property in your sole name without a current beneficiary designation. Taking this one step further, ensuring that the provisions of the trust you created will govern the management and ultimate distribution of your accounts and property after you pass away, requires that you have either properly transferred ownership of your accounts and property to your trust or named your trust as the beneficiary. Let's talk about what kinds of things go through probate. Under what conditions will your loved ones have to go to the probate court to administer and distribute your accounts and property after your death? Well, let me give you a couple of examples. Your accounts and real estate are titled in your sole individual name without there being a payable on death or a transfer on death designation. Maybe you have accounts and real estate jointly owned with someone else as tenants in common. If you have retirement accounts that don't have any named beneficiaries, and also if you have life insurance policies that do not have named beneficiaries on them. Let's talk about how can you ensure that your accounts and property do avoid the probate process. So the types of accounts and property that will automatically avoid probate after you pass away, and therefore do not need to be funded in your trust, are different types of accounts in real estate. So maybe it's accounts in real estate that you owned as joint tenants with right to survivorship. That means that your interest in the accounts in real estate would transfer automatically to that surviving owner by operation of law. So there's no need for probate. Or if you have accounts in real estate owned by a married couple as tenants by the entirety, your interest in the accounts in real estate will transfer to your surviving spouse automatically at the time of your death and by operation of law, leaving them the sole owner of that property. If you have life insurance and you have a beneficiary designated on that policy, there'll be no need for probate. So in many instances, you may choose to name your trust if you've created one as the beneficiary of your life insurance policy. Naming your trust as the beneficiary will cause the life insurance proceeds to flow into that trust after you've passed. Now, with retirement accounts and 401ks and annuities, if you've designated a beneficiary on the account, or the plan has default rules requiring that the account be distributed to a specific person or a group of people, if there's no named beneficiary, then that account will go to that person or to the people by operation of law or per the terms of that contract. You might also consider naming your trust as the beneficiary of the retirement account so that the account will flow into your trust at the time of your death. Now, for payable on death and transfer on death accounts, and in some states, they actually have a transfer on death or beneficiary deeds for real estate. Massachusetts and New Hampshire is not one of those states. So accounts or real estate with these type of designations will automatically transfer to the named beneficiary upon your death by operation of law, so there's no need for probate. So what happens if you forget to fund your trust? Life is ever-changing, and you could overlook an account or property when funding your trust. Or you could take all of the steps necessary to ensure that all of your current assets are in the trust at the time of your death, but then acquire new accounts or property and forget to fund the new items into your trust. If one of these situations arises, your loved ones may have to open a probate process at your death to handle any accounts or property that were in your sole name without a beneficiary designation. Ideally, when you created your trust, you also created a pour-over will, which instructs the judge in a probate administration or transfer to transfer all of those accounts and property in probate to your trust during the probate process. So even if your loved ones end up having to go through probate, the accounts or property will eventually end up funded into your trust and managed according to the trust instructions. While this situation is not ideal, and in many states may be very expensive and time consuming, the ultimate outcome is that your trust remains the sole vehicle for managing and distributing all of your accounts and property. So to ensure your estate plan is set up so it doesn't have to go through probate, you want to speak with a qualified estate planning attorney to make sure and confirm that your trust is fully funded and that all of your accounts and property are aligned with your estate plan. Remember, creating a revocable living trust is just the first step to avoid probate, and property ownership is the ultimate key. So I want to thank you for watching. Please like and subscribe our page below to keep up to date and get notifications of new topics and videos that we will release on estate planning in order to help all of you better understand estate planning and how it can benefit your family. Till next time, I'm Attorney Kelly Longtin from Kelly Longtin Law.